Good afternoon, ladies and gentlemen, and welcome to the 2016 Thornberry Lecture on International Law and Human Rights. My name is Mario Prost. I'm the director of the Keele LLM in International Law and a member of the organizing committee for this lecture series. I'm very pleased to be here today and to chair this event. I fully realize that this is a very nice, warm and sunny day, and you could have elected to just stay out and enjoy the pleasures and the wonders of spring on our beautiful campus. So thank you very much to all of you, colleagues and students, for being here today. I won't speak for long. I'm just going to say a few words of introduction about the Thornberry lecture series and just pass the floor to Patrick, who's very kindly agreed to say a few words of introduction about our distinguished speaker today, Mark Latimer. So the Thornberry lecture was established last year in 2015 in honor of Patrick Thornberry, who is an alumnus and emeritus professor of international law here at Keele. We wanted to establish a new lecture series to mark the renewal and vitality of international law and human rights studies here at Keele. And it was obvious from the start that this lecture series should be named after Professor Patrick Thornberry in light of his outstanding contribution to the field of international law and human rights and his outstanding contribution to the study of these subjects here at Keele. Patrick has had a quite extraordinary and inspiring career, as well as his academic position as Professor of International Law here at Keele. Patrick has been a visiting professor at various institutions around the world, including the European University Institute in Florence. He has acted as a human rights consultant to a variety of governments, as well as international and European organizations. And until recently, Patrick was a member of the UN Committee on the Elimination of Racial Discrimination, for which he was appointed rapporteur between, I think, 2002 and 2008. Patrick is widely regarded as one of the most prominent legal experts in the world on minority and indigenous rights. He has authored more than 100 books and papers on race, indigenous, minority questions in international law, and he has to a great extent been instrumental in establishing minority rights and indigenous rights as new autonomous fields of study. The French philosopher Gilles Deleuze used to say that there are two broad categories of intellectuals in life. First are les passeurs de savoir, the knowledge conveyors, those who pass on existing knowledge onto others and apply existing knowledge to new objects. And then there are les casseurs de savoir, the knowledge breakers, those who break new grounds, break old categories, make new categories in a way that can profoundly transform their academic discipline, and in some cases even lead to the emergence of new academic disciplines. Patrick very firmly and clearly belongs to the second category. His work has profoundly changed the way that we think about minority and indigenous issues in international law, and he is rightly regarded by many in the field as one of the founding fathers of minority rights and indigenous rights as intellectual disciplines. And then, of course, Patrick has been an inspirational educator. He has taught and inspired many generations of students, some of whom are in the room, many others currently working as world-leading academics, practitioners, or international civil servants. So Patrick has had an exemplary career as an intellectual, as a pioneer of minority and indigenous rights studies, as a relentless human rights advocate, and, as I just mentioned, as an inspirational educator. So, please, ladies and gentlemen, join me in thanking and welcoming Patrick to the 2016 Thornberry Annual Lecture in International Law and Human Rights.
Thank you very much indeed. That was a very, very generous tribute, Mario, and it's actually very touching, so thank you so much for that. I think my task today is to, well, thank you and thank the organising committee, thank the university for organising this series of lectures, which is extremely gratifying, and it's a great honour. But my task now is to briefly introduce Mark Latimer. Mark, and I'm really delighted and honoured that you've can be present with us today, and it's I know you have a very busy schedule as indeed Director of Minority Rights Group International. I think the organisation was founded by David Astor, I think back in 1969, and I became involved with the organisation probably in the 70s and 80s, but I knew a number of directors in turn. Well, notably Ben Whittaker, the late Ben Whittaker, and Alan Phillips. And now we have Mark, who was appointed when I was chair of the Council of Minority Rights Group, and it's proved to be a great appointment, put it that way, a great appointment. I've seen Mark at work on many occasions. I think the initial experience was in Bangalore, actually looking at Dalit issues. The many subsequent occasions seen him in operation at the United Nations and other organisations, driving MRG forward and making MRG a tremendous and authoritative presence, I think, on issues of minority rights in international law and international relations. I'm sure you're familiar with the broad output of MRG, but the individual reports are extremely important. And I notice a certain movement in recent reports to issues in the Middle East, to do with various minority groups in Iraq and Syria under threat. And Minority Rights Group also produces an annual volume now, The State of the World's Minorities and Indigenous Peoples, which I think also has a section on peoples under threat. And that is the focus of MRG, and they have maintained it very solidly under Mark and developed its profile enormously. I think you've also developed quite a very, very impressive legal arm in terms of providing briefs on important cases. I think notably the Endroy's case before the African human rights system and other cases. Minority issues of Mario's kindly suggesting that I'd help to develop some of the ideas about minority rights in the 80s and 90s. Of course, classically, minority rights were often to do with issues of language, education, culture. But I think MRG's approach is wider. You're looking at threats in a totality against the very existence of minority groups. They certainly include the earlier preoccupations, but transcend them also. And again, I've said I've seen Mark at work, very, very good at engaging with governments at the United Nations, very good at bringing the truth to them. I was very impressed in 2014 when I chaired the United Nations Minority Forum that Mark, with MRG, brought forward many Yazidi women from the Yazidi communities, to give direct testimony of what they had experienced. And that was, I think, very impressive and very moving. And governments became even more aware than they were of what had been developing. And you've also managed, I think, to keep your academic stream going. We'll hear some of this more today, notably in a publication, if I recall, with Philippe Sands on justice for crimes against humanity. Strangely enough, when I Googled that up this morning, obviously somebody had misrepresented it. And instead of calling it justice for crimes against humanity, up on Google it came up as justice or crimes against humanity. So the answer is, which do you prefer? I don't know. But anyway, it actually seems to have stemmed from a particular review in one of the journals who missed off one letter, which can be extremely important. Anyway, Mark is talking on concepts of human rights today and how they relate to the kind of work to do with deep issues of identity and existence that characterizes the everyday menu, I suppose, of minority rights groups. So without more ado, I just pass you over to Mark Latimer with thanks from myself and the university.
Well, I'm very pleased to be here and to have so many of you in the audience today. A few thanks, obviously, to Dr. Mario Proust and for organising this lecture and for introducing it, and also to Keele Law School and Margaret Moyden for her kind assistance. When Mario first invited me to give the Thornberry lecture a few months ago, I immediately realised that I had to say yes for a very particular reason. As Patrick has already spilt the beans, he was actually my boss some 15 years ago for a couple of years. And I immediately realised that finally this lecture gave me the chance to get my own back. There are some academics who achieve a lot of success, and it's not necessarily related to intellectual achievement. They achieve a lot of success through their ability to promote their ideas, through their PR skills, and their mastery of social media. Patrick is not one of those academics. He is also not actually a controversialist. I sort of respectfully disagree with part of what my friend Mario said. If we are going to characterise Patrick in Deleuzian terms, then I think he is maybe a casseur de savoir in impact, but perhaps a passeur de savoir in method. And certainly I've always admired the way in which he has a deep respect. He's an active listener. He has a deep respect for the views of others, no matter whether they're qualified or not, and no matter where they come from. And I think that has always shone through when I have seen him, certainly at the United Nations. He's also, and Mario is absolutely right, has been one of the very few who have single-handedly created this discipline of minority rights, and up to a point also indigenous people's rights. We have come a long way. We now have UN mechanisms, regional mechanisms dedicated to minority rights. It has become a discipline in its own right. That, of course, is the primary responsibility for that is, of course, with the thousands of minority activists around the world who, often at great risk, are fighting the fight for their communities. But it's also down to a very few people who have elaborated the content of minority rights, who have tried to give it an internal coherence, and who have persuaded states to accept it as practice. And Professor Thornberry is foremost amongst those. He has, I'm pleased to hear that people are aware of his international reputation. Patrick has students, literally thousands of students all over the world. So some of them have studied here, some of them meet him at the UN, but I know that the majority of Patrick's students have never met him at all. But they read Thornberry, they study Thornberry, and perhaps most importantly, they cite Thornberry when they need some serious authority to back up their own cases for human rights. So it really is an honour to give this lecture in Patrick's name. Just over 4 years ago, I found myself surrounded by about 250,000 people in Tahrir Square in Cairo. It was a stage in the Egyptian revolution when hopes were still very high. The protests that day had been almost entirely peaceful. The Egyptian security forces had long moved back from the square. In fact, the only people who were hurt that day were protesters who'd suffered crush injuries, and I remember were borne aloft on the shoulders of their fellow protesters to one of the sick bays established either in the mosque on the corner of the square or in the church 1 block behind the square. But what struck me that day, other than just being awed by the power of a crowd that large, what struck me very forcefully was how the demands of the protesters were almost entirely expressed in terms of human rights. Bread, dignity and freedom was the usual chant. Sometimes a fourth demand, justice, was added. Now, if you're going to have 4-word summaries of the international human rights canon, that's not a bad one. From my point of view, as a sort of small-time human rights professional who'd got to thinking about human rights as a way of just trying to temper some of the worst abuses around the world, or as a way of incrementally advancing the situation of some of the most marginalised people. I think what struck me also was the sheer ambition of the protesters. What they were asking of human rights, what they expected from human rights, was nothing short of a transformation. Now, it might be tempting, particularly for the lawyers amongst you, to dismiss such expectations as being a sort of purely metaphorical use of the term human rights, or as articulating essentially a political or moral claim rather than a legal one. But those expectations are so persistently voiced by human rights activists around the world, who are in a position to know what they are talking about, as well as finding a grounding in the history and philosophy of human rights, that I think we need to take them seriously, even if it means rethinking some of the legal categories or touching on the relationship of justice to human dignity, or even what it means to be human. When we hear it said that basic human rights must be protected, or also, and often at the same time, we want a society based on human rights, are those essentially the same demands? Does the term human rights mean the same in both cases? If they are different, is it just a difference of rhetoric or of substance, or a question of degree? What implications do the answers to those questions finally have for the implementation of human rights? Now, despite the rapidly growing number of international human rights treaties codifying the content of human rights, it strikes me that the term human rights continues to be used in public discourse to denote a wide range of really quite different concepts. Today, I just want to talk about 2 such concepts, but ones that I think are particularly important. Human rights are most often defined as those rights which human beings possess simply by virtue of being human. That, I would guess, is still the most common explanation given in law schools and human rights courses around the world. It's a definition which invites thinking of human rights as a set of basic minimum standards for human treatment. But the Tahrir example, I hope shows us that the term human rights is often employed, albeit sometimes implicitly, also in a rather more ambitious way, to denote the rights that constitute the human. That is, human rights are the rights that make us human. Now, I want to say in a few words to sort of briefly sketch out some of the philosophical foundations of those two concepts, and also some of the implementation for rights in practice. But maybe first, one illustration. Many of the most pressing human rights concerns of our time are articulated in terms of identity struggles by those whose rights are violated, for example, on grounds of ethnicity, of religion, or on grounds of gender identity or sexual orientation. Can such movements really be reduced to a plea for decent human treatment? I don't believe they can. This is actually effectively recognised by the international law of human rights. For example, Article 27 of the International Covenant on Civil and Political Rights, which guarantees the rights of persons belonging to minorities, has been described by our own Professor Thornberry as conferring a right to identity. He's surely correct. Certainly, that's what it feels like in practice, where the recognition of identity comes both at the beginning and also at the end of the process of trying to secure minority rights. Official acknowledgement of the identity of a minority is typically a prerequisite for the long process of dismantling structures of discrimination and establishing guarantees of treatment which will in the end allow that identity to flourish. As the Human Rights Committee, the UN Human Rights Committee, has itself stated, the protection of these rights is directed towards ensuring the survival and continued development of the cultural, religious and social identity of the minorities concerned, thus enriching the fabric of society as a whole. Now, the title of my remarks today are clearly a nod to Isaiah Berlin's celebrated essay, Two Concepts of Liberty, and some of the method that I am going to follow mirrors his. But the distinctions that I want to make are fundamentally different. Berlin, you'll remember, distinguished between negative liberty, conceived broadly in Hobbesian terms as the absence of external impediments on individual action, and positive liberty as self-mastery, subjectivity, or self-direction, encapsulated in the wish to be the instrument of my own, not of other men's acts of will. More recently, the Cambridge philosopher Quentin Skinner has analysed the opposition in Hobbes' later thought between his negative conception of liberty and what Skinner terms neo-Roman or republican liberty, understood as the absence of arbitrary power or freedom from dependence. Both these sets of distinctions, both Berlin's and Skinner's, are therefore primarily ones in the field of human agency. They're concerned with what individuals can or cannot do, rather than with how they're treated, the conditions in which they live, or even what individuals are or what they could become. So some might argue in retrospect that it's possible to construe the struggle for rights in the 17th century as broadly synonymous with the struggle for freedom. But in our own age where human rights are numbered in the scores, if not the hundreds, in an age of positive obligations to fulfill human rights, to reduce the concept of human rights to a theory about individual agency clearly won't do. In contrast to the distinctions then made by Berlin and by Skinner, the two concepts of human rights that I want to talk about are both more narrow, being concerned only with those freedoms that we call fundamental, and at the same time much broader, going beyond human agency to questions of human nature and human identity. The two concepts of human rights mark less a difference in agency than in ambition. And while they could be summarized as a minimalist and a maximalist conception, one could also be seen as an operational principle in the development of law, and the other partly as a grounding or principle of legitimacy for the legal order itself. Nor is the distinction I want to make between the standard generations of rights. Although the concept of human rights, the concept of the human rights baseline can be seen as more influenced by classical political liberalism and by legal positivism, it lays as great an emphasis on economic, social and cultural rights as it does on civil and political ones. And as we shall see, both concepts of human rights are informed by natural law, although their ends are very distinct. One posits rights as a basic standard of human decency, and the other conceives of rights as the realization of human dignity and potential. So I'd like to say a few words about each of these two concepts in turn and where they come from. First of all then, rights as a minimum standard for human treatment. In The Law of Peoples, John Rawls argues that human rights specify limits to a regime's internal autonomy and express a special class of urgent rights, the violation of which is equally condemned by both reasonable liberal peoples and by decent hierarchical peoples. Far from tending towards a political ideal, human rights here are valued both by liberal peoples and what Rawls calls hierarchical peoples equally, making them in that sense politically neutral. They're limited to urgent rights, a point heightened by his use of the word special. For John Rawls then, this restricted conception of human rights makes them compatible with value pluralism and enables them to be subject to international consensus, a point extremely important for the formulation of the international law on human rights. But the idea that human rights are essentially protections against abuses of power, particularly serious abuses of power, is so widespread as scarcely to need much citation. So the entry on human rights in the Stanford Encyclopedia of Philosophy begins, "Human rights are norms that help to protect all people everywhere from political, legal and social abuses." Human rights, says Xu, are not concerned with great aspirations and exalted ideals, but rather with the lower limits on tolerable human conduct. This has a long history. Admonishments to rulers and masters not to be cruel to those under their power were common in classical writers. Grotius, the father of international law, quotes Justinian to make a point about how something that is legally permitted can still be forbidden. His example is that of slavery. He says that although all things are permissible against a slave, yet there is something which the common law of living things forbids to be permissible against a human being. The constraint here is internal, Grotius notes, treating it under the general heading of a sense of honour. But what's really interesting is how the slave's formal legal permission is trumped in this case by his or her status as a human being. For Hobbes, this last form of protection is not seen as something internal to the master or sovereign, but rather as inalienable rights of the subject. Now, Hobbes's reputation as the philosopher of absolute sovereignty is such that I think scholars have tended to underestimate the extent of this inner core of rights that remain even after the subject has transferred all his other rights in the mechanism of the social contract. In the great 14th chapter of Leviathan, under the marginal head, "Not all rights are alienable," Hobbes explains, "There be some rights which no man can be understood by any words or other signs to have abandoned or transferred. These include the rights of resisting deadly assault, and also resisting wounds and chains and imprisonment. These are logical exceptions, as the motive for the mutual transfer of rights in the contract is nothing else but the security of a man's person in his life and in the means of so preserving life so as not to be weary of it." But in chapter 21 of the Leviathan, the list of rights in the inner core is expanded. Man cannot be bound to abstain from the use of food, air, medicine, or any other thing without which he cannot live, even if he's justly condemned, nor to kill any other man, nor in many cases to go to war. Then there is this, an early formulation of the privilege against self-incrimination in criminal law. If a man be interrogated by the sovereign or his authority concerning a crime done by himself, he is not bound, without assurance of pardon, to confess it, because no man can be obliged by covenant to accuse himself. So from here, it's not a great theoretical step to the procedural protections against sovereign excess in the English Bill of Rights of 1689, or the sort of due process guarantees in the American Bill of Rights. Although protections against certain egregious violations of physical integrity, such as slavery or torture, are absolute as well as inalienable, it's intrinsic to the concept of the human rights baseline that when fundamental freedoms, like freedom of expression, freedom of religion, freedom of assembly, and so on, are added to the inner core, then they are subject to limitation. What those limitations might be can be derived from Kant. "No one can compel me," Kant explains, "to be happy in accordance with his conception of the welfare of others, for each may seek his happiness in whatever way he sees fit, so long as he does not infringe upon the freedom of others to pursue a similar end, which can be reconciled with the freedom of everyone else within a workable general law, i.e., he must accord to others the same right as he enjoys himself." This is effectively a near complete sketch for the system in contemporary human rights law for assessing acceptable limitations to fundamental freedoms, including the tests of legality, proportionality, necessity, and non-discrimination. It's important to note that even at this point in the development of human rights, the idea of a minimum standard was not exclusively concerned with protection from government excess or rights to physical integrity or civil liberty. In Agrarian Justice, Thomas Paine enlarges on his arguments in The Rights of Man to present a fully elaborated justification for a basic minimum income as a right, not a charity. His plan, financed by the payment of a ground rent by landowners, is for a lump sum of £15 to be made available annually to everyone on their coming of age, and an annual pension of £10 for the blind, the lame, and for everyone over the age of 50. The aim of such a minimum income was to relieve poverty, but also to compensate the landless for the loss of their natural inheritance. And as a right, it would be universal and unconditional. Now, the modern idea of international minimum standards for economic and social rights has become entrenched, certainly in the field of labour rights, as the numerous conventions promulgated by the International Labour Organization attest. But in other areas, it would seem to present greater problems on account of the huge disparities in wealth between different countries. This is actually acknowledged in the leading human rights instrument, the International Covenant on Economic, Social and Cultural Rights, which in Article 2.1 actually limits the obligations on states by undertaking, framing the obligation on states parties to take steps individually and through international assistance and cooperation to the maximum of available resources, with a view to achieving progressively the full realization of the rights recognized. So we see a commitment to a process rather than to an absolute standard, but nonetheless an attempt to create a baseline of provision. Now, this task has developed hugely in recent decades, particularly as a focus for international cooperation. The Millennium Development Goals, agreed by the world's governments at the UN World Summit in 2000, have recently been replaced by the new 2030 goals, the Sustainable Development Goals, as an international set of development targets rather than as rights. They're neither individual or group rights. So they don't provide legal remedies, and they're not, strictly speaking, justiciable. But the operational effect of, say, MDG Goal 2 on achieving universal primary education, or Target 3A on eliminating gender disparity in education, is not actually so different from what in human rights terms might be described as the positive obligations on a state party to the International Covenant or to the Convention of the Rights of the Child to fulfill the right to education to every primary age child in the jurisdiction without discrimination. The relative success of these international development goals in establishing not just targets for international development, but also national standards for judging state performance, demonstrates how powerful this baseline concept is for generating international consensus. It's also evidenced in the proliferation of UN-sponsored minimum standards containing highly detailed procedural safeguards for due process and protection of civil rights. For example, the minimum standards on the treatment of prisoners, or on the use of firearms and force by law enforcement officers. The basic or minimum quality of these standards enables them to avoid that more difficult conceptual territory where cultural, religious, or political differences are more likely to arise. At the same time, their black letter quality, the tendency to positivism, if you like, facilitates the certification of violations, legal findings, and also, one could argue, helps expose weaknesses in the standards themselves, prompting reform. So the baseline concept of human rights is both very powerful and, as a basis for international consensus, highly persuasive. But I want to say a few words about the second conception of human rights, the rights that constitute the human. Article 1 of the 1948 Universal Declaration of Human Rights begins, "All human beings are born free and equal in dignity and rights." Now, as a descriptive statement applied to any known human society, this statement is demonstrably false. But as a normative statement, speaking to our common humanity, it enjoys nearly universal acceptance in the world today. It's going to be beyond the scope of my brief remarks to try and sketch the construction of what we mean by the human in the history of ideas. But I think I want to give a few examples just to show the richness of Article 1's philosophical lineage, illustrating how the notion of the human interrelates with the notion of justice to produce this conception of rights, this alternative concept of rights that are constitutive of humanity. The first sentence of the Universal Declaration's Article 1 is a statement about human rights, but it does seem to go further and supply at least a partial vision of justice. Read literally, it says that equality in dignity and rights is an inherent part of the human condition prior to the workings of human society. Now, we associate the idea of human rights with modernity, but the idea that justice is both older than law, older than human law, and intrinsic to existence is as ancient, certainly, as the oldest recorded text of Western philosophy. Whence things have their origin, there they must also pass away according to necessity. For they must pay penalty and be judged for their injustice according to the ordinance of time. Now, Heidegger warns us against interpreting that, what we call the Anaximander fragment, as reading it as a kind of primitive natural science. He notes that beings is probably a better translation from the original Greek than things, so whence beings have their origin, and that man, things produced by man, and the situation or environment affected or realized by the deeds and omissions of man are even more in being than mere things. Justice, then, for Heidegger, and in his reading of the fragment, governs the becoming of beings. But the moment at which justice comes to dwell in the house of man is dramatized at the end of the Oresteia. Athene proclaims, "Citizens of Athens, as you now try this first case of bloodshed, hear the constitution of your court." And it's conventional to read the birth of the court in the Eumenides as the ending of the eternal cycle of vengeance through the institution of the legal process. But in the play itself, it's a rigged affair. You'll remember that both Apollo and the Furies continue to invoke justice on their side and actually threaten the citizen jurors with dire consequences even as they cast the jury's vote. Under the circumstances, the tied or balanced verdict is really the only possible outcome. And in a manoeuvre not unfamiliar to lawyers since, the Athenians as well as Orestes use the law to escape justice. But our understandings of the workings of law and justice in practice in classical Athens now comes primarily from Aristotle, of course. While human rights, as we now conceive them, are alien to Aristotle, certainly in the sense of a system of individual protection against governmental power, human nature and the order of the polis are intimately connected. Each tends to the good through the other, and each is in some sense constitutive of the other. Indeed, the state is by nature clearly prior to the family and the individual, Aristotle states in the Politics, and its principle of order is the administration of justice. So all that is required now to take us from this concept of man as the zoon politikon, as the political animal, to the first article of the Universal Declaration, human beings are born in rights, is a theory of natural right. The direct antecedent to Article 1 of the Universal Declaration is, of course, the French Declaration of the Rights of Man and the Citizen, from whose own first article it is nearly a quote. Men are born and remain free and equal in rights, is the French Declaration's version. Now, for the drafters of the French Declaration and their philosophical fathers like Rousseau, the state of the human at birth, like the state of nature, provided both a metaphor for political innocence and a powerful critical perspective on the old order that they were repudiating. It's curious then that the innocence doesn't apparently extend to the legal sphere, since men are born in rights. The answer is that such rights are natural and derived not from a higher authority, but from reason. As the American Declaration of Independence states, these truths are self-evident. It was Hobbes again, who first located the seat of natural right, jus naturale, in the human, and saw from it spring the whole positive legal order in the institution of the original contract. Hobbes, for whom the state of nature was altogether less attractive, doesn't quite go as far as to define human nature in terms of natural right, but he does make the concept of natural right do a lot of work. It is both the natural right of every man to everything, and also the cause of a fundamental law of nature, the sum of the right of nature, which is, by all means we can, to defend ourselves. Kant remarks that people's views on empirical ends and what they consist of, which he sums under the general heading of happiness, are sufficiently varied that in that respect their will cannot be brought under any common principle, nor thus under any external law. But the establishment of the lawful state is steered by the pure rational principles of external human right. So these principles may not encompass all people's wills and all people's views, but they do therefore define the common humanity that we share. Natural rights, discovered by reason, have become a politico-legal expression of human identity. Divorced here from the turbulent world of experience, is there nonetheless something which is missing from this incipient notion of constitutive human rights, of human rights which are understood as defining the human? Well, one person who attempted to complete it in one way was Jacques Lacan, who rather archly pointed out that Philosophy in the Bedroom, that great work by the Marquis de Sade, completes Kant's critique of pure reason. The critique of pure reason was only published 8 years before Philosophy in the Bedroom. He argued that he completes it because the Sadean pursuit of jouissance is the full realization of the value that Kant places on freedom, and is moreover in accord with Kantian ethics because it is a universalizable principle. Now, I don't really have the space, and I doubt whether I have the credentials to talk about the treatment of human rights in the psychoanalytic tradition. But I think it is worth just pointing out that the whole of psychoanalysis presents quite a significant challenge to the notion of the constitutive theory of human rights, simply because it posits the human subject as fundamentally divided. How can we think of constitutive human rights in a post-Freudian world where the subject is not unified? What part of what we call human would we describe as being constituted by human rights? Can human rights be at once the legalization of desire in Lacanian terms, and also the transgressive principle inherent in jouissance? If desire signifies precisely the excess of demand over need, as Dusinus describes it, are human rights demands necessarily always excessive? I think these are profound questions for any notion of human rights that attempts to constitute what we mean by the human. Now, I've tried over the last 20 minutes or so not to give a sort of detailed philosophical history of these two concepts of human rights, but instead really just to pull out a series of examples or traces of the two concepts in the history of ideas. Rather than lining up philosophical traditions on one side or another, I think it's been interesting to look at how the founding for both concepts can be found in many different philosophical traditions, including a grounding for both concepts in the work of Hobbes and Kant, even if we are occasionally reading them a little against the grain. But while the two concepts are clearly distinct and tend towards different ends, there is also traffic between them. The constitutive approach necessarily includes the baseline approach, not just in the formal sense that the maximal has to encompass the minimal, but because basic human rights are a necessary component of any more expansive definition of rights. The choice of which minimum standards to select involves answering the question, what are the essential levels of physical and economic security and individual autonomy which enable the human being to function as a human? Once selected, such standards inevitably, therefore, point to something essential in human nature. Perhaps the analysis that comes closest to synthesizing the two concepts is contained in the capabilities approach developed by Amartya Sen and Martha Nussbaum, which assesses well-being by people's, and I quote, abilities to do and to be certain things deemed valuable. In Nussbaum's own account, this approach articulated the Aristotelian idea of capability, dunamis in the Greek, in terms pertinent to the contemporary debate, in which is strongly emphasized the importance of rights. She accordingly linked the capabilities approach to an account of the proper goal of government to bring all citizens up to certain basic minimum levels of capability. More recently, she stated that it begins with a commitment to the equal dignity of all people and is committed to the attainment for all of lives that are worthy of that equal dignity. But as soon as Nussbaum sets herself to producing a list of the indispensable central human capabilities, it's clear that they seem to go beyond a basic minimum level. So, number 4 in her list senses, imagination and thought includes the following: being able to use imagination and thought in connection with producing expressive works, religious, literary, musical, and so forth. And number 5, emotions, includes being able to have attachments to things and people outside ourselves. Does this mean that an individual who is not capable of, say, producing a literary work or of forming emotional attachments cannot live a life worthy of human dignity? This is not, I should say, a criticism of the capabilities approach as a way of thinking about human development, where I think it is highly persuasive, but simply to point out a problem with conceptualizing the approach as a human rights method, or at least as one founded on basic minimum standards. For our purposes, it illustrates a general problem. As human rights demands become more detailed and more comprehensive, more constitutive, the weight of human diversity they attempt to bear almost becomes too much, and there's a danger of the edifice collapsing. But the process, including the dialectic between the two concepts of rights, has proved creative, and I would say is probably one of the main drivers for progress in the human rights movement as a whole. Even if these two concepts of human rights resist any formal synthesis, this doesn't mean that they never coincide. In fact, they have come together, and no doubt will do again, at a particular historical moment, the moment of revolution. Article 2 of the French Declaration proclaims, "The aim of every political association is the preservation of the natural and inalienable rights of man. These rights are liberty, property, security, and resistance to oppression." Now, even allowing for the fact that the use of the term political here has a much narrower connotation than, say, in Aristotle, reducing the aim of political association, of all political association, to the preservation of the rights of man, strikes even me as a human rights activist as being unacceptably limited. What about looking after the needy in society? What about economic prosperity? What about the advancement of the common good? For that matter, what about sanitation and refuse collection? At the moment of revolution, and for that moment only, human rights exhaust the role of government. Now, there is nothing in the international law of human rights that can imply a right to resistance itself, and nor could it in a system that is essentially created through multilateral treaties concluded by sovereign states. But if we look at the great revolutionary declarations of the late 18th century, we can see that they document the point at which the demands of the oppressed suddenly flower into the constitution of a new order. And as if in homage, the documentary model followed by virtually all modern international human rights instruments is the same. They begin with an expansive statement of human values and norms in the preamble, but then the operative articles quickly settle down to the enumeration of specific protections. For at the moment when the new authority has the power for the first time to guarantee protection, it also assumes the power to define what constitutes the human. either explicitly in the promotion of values or implicitly by exclusion. And in the case of the French Declaration, of course, that meant excluding women and non-citizens, as well as, in practice, minorities, which makes those protections offered by human rights never more important. But I think that the distinction between these two concepts of human rights is useful, not just because it helps to map the space between the minimalist and the maximalist positions in which human rights demands are typically negotiated, but also finally because it focuses attention on the question, who owns human rights? Are human rights primarily a principle of good government and therefore a matter of state, or are they primarily a cause for civil action in both the political and legal senses of that term? If human rights are more than simply limits on a regime's internal autonomy, who has the power to define them and to make them effective? I'll just finish by saying that much has been written by poets as well as philosophers and constitutional lawyers about the revolutionary moment. The moment when hopes are crystallized or dashed and the light of day shines in over the dreams. For precisely those reasons, it's often, perhaps inevitably, a moment of disappointment, as virtually all those protesters in Tahrir Square found. Popular revolutions can also hold particular dangers for minorities, old and new, who have good reason to fear majority rule. Human rights, too, can never be completely realised in a world where human society is imperfect and human nature, arguably, is in flux. This holds a lesson for both concepts of human rights that I've tried to sketch today, but I think it presents perhaps the greater challenge to the maximalist conceptions where the stakes are higher. Rights which seek not just the establishment of a baseline, but aim at a transformation in power relations or at the realization of human identity. For its part, the liberal conception of human rights, that is, human rights as a minimum standard, always attempts to limit or deny the transformative power of human rights. But it never succeeds in extinguishing it. It always remains as a possibility and specifically as a threat. As the mother of human rights standards, the Universal Declaration of Human Rights itself reminds us, it's essential that human rights should be protected by the rule of law. If man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression. Thank you.